What's up, everybody? My name is Christian Connor. I'm a BASTROP Texas real estate agent. I'm on the Frank Ronoshek team at the RE/MAX BASTROP area, and today we're doing a deep dive into the 1 to 4 family residential contract resale. So, for single family, 1 to 4 family homes, alright? So we're gonna go through this pretty in depth. So, got like 15 minutes, sit down, just get in. So, first part is parties. The parties to this contract are going to be Robert Strassman, the seller, and Devon Jones and Christine Jones as the buyers. Number 2, the land improvements and accessories that are collectively referred to as the property. Land and the block and blank addition of are all going to be the legal description. You're going to find that in the CAD or on the legal description of the property. So we have the city of blank, county of blank in Texas, known as the address. So in this example, we've got Plano, county of Cullen, and Texas, known as 1233 Tree Lane, Plano, Texas, 75093. So, we're working with 2B, the improvements. This includes built-in features and fixtures that are a part of the property for sale, like built-in appliances and attached garages. Accessories is 2C, list of movable items included in the sale, such as a window air conditioning unit or swimming pool equipment. Exclusions 2D, items the seller wants to keep and move with them is going to be listed here. Reservations, any rights not included in the sale, like mineral rights, can be reserved by the seller with details specified right here. So, number 3, we've got the sales price. We have the sales price. So, this is the breakdown of the total price into the cash portion, and the buyer will... Sales price, this is the breakdown of the total price into the cash portion that the buyer is paying up front and the financing amount. And we're going to ensure that right here we got a lot of clarity, otherwise we're going to have some disputes. So right here we have the cash portion and then the financed amount, and then finally that down payment right there. Leases. Except as disclosed in this contract, seller is not aware of any leases affecting the property. After the effective date, seller may not, without buyer's written consent, create a new lease, amend any existing lease, or convey any interest in the property. So this first one, A, residential lease, that's going to be if there's a tenant. B, a fixture lease. B, a fixture lease. So if the seller doesn't own their solar panels or doesn't own their propane tank, it's going to be there. A natural resource lease. So if there's an existing oil or gas, mineral, water, wind, or other natural resource lease that affects this property, to which the seller is a party, they're going to have to include that there. And so you either 1 or 2. Obviously, only if you have the lease, then you'll have to give that to the buyer. And if you haven't already given it to the buyer, then you have to agree upon an amount of days before you have to give that to that buyer. So, page 2, we got number 5, earnest money and termination option. So we're going to specify the amount, who's going to hold it, and the conditions for its refund, and this acts as the buyer's deposit and shows their commitment to this property. So we've got the title company in that first one right there, and then we have at the title company's address, the amount of earnest money and the amount of option money. And if there's going to be additional earnest money added later, we're going to put that there, and it's going to be delivered in an agreed upon amount of days there. So, if the last day to deliver that earnest money option fee or the additional earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver that earnest money option fee or the additional earnest money as applicable is extended into the end of the next day that is not a Saturday, Sunday, or legal holiday. Pretty self-explanatory. The amount that the escrow agent receives under this paragraph shall be applied first to the option fee, then to the earnest money, and then to the additional earnest money. Buyer authorizes escrow agent to release and deliver that option fee to the seller at any time without further notice or consent from the buyer, and releases escrow agent from liability for that delivery of that option fee. The option fee will be credited to the sales price at closing. Termination option. So that's what you're buying the option fee for. So in this case, they paid $275 to have 7 days of termination option. Within those 7 days, the buyer has the right to completely terminate the contract for whatever reason they see fit. Number C and, well, I guess letter C and letter D, failure to timely deliver earnest money. If the buyer fails to deliver that earnest money within the time required, the seller may terminate this contract or exercise seller's remedies under paragraph 15 or both by providing notice to the buyer before buyer delivers that earnest money. B is failure to timely deliver the option fee. If no dollar amount is stated as the option fee, or if the buyer fails to deliver that option fee within the time required, the buyer will not have the unrestricted right to terminate this contract under paragraph 5. E, time. Time is of the essence for this paragraph, and strict compliance with the time for performance is required. So basically, even if you're off by a few minutes of executing this contract, then the contract is now void. Cool? Cool. 6, title policy and survey. Seller shall furnish to the buyer at, in this example, the seller is paying for it, an owner policy of title insurance, and it's going to be issued by that same title company. So we've got title policy, which is just title insurance, which is every single transaction. And then right here below 8, we have will not be amended or deleted from the title policy, or will be amended to read shortages in the area at the expense of either the buyer or the seller. In this example, the seller's paying for it. So if you're worried about what's going to be on the title in the survey, you're going to check the second box, and if you're not worried, then you're going to check that first box where it says will not be. And at the bottom here, commitment, it's just basically stating that the seller's got 20 days to give it to the buyer. C, the survey. So there's going to be 3 options for the survey. The first one is the T47 affidavit. So if you've got a previous survey for that property, but the seller doesn't give the survey up, or if the survey is not acceptable, then either the seller or the buyer is going to have to pay for a new one. And option 2 and option 3 are if there's no existing survey, and either the buyer is going to pay for it or the seller is going to pay for it. So in this example, the seller is paying for it, and they're giving them 10 days to get it to the buyer. Objections. So if the buyer finds something wrong on that survey that they're not cool with, they're going to put it here, and an agreed amount upon the days right there that they have to object, basically. Title notices, abstract or title policy. Basically, that's protecting us as the agent or broker, and basically acknowledging that we are advising the buyer to have an abstract of title examined by an attorney, which is the title's history, just to make sure the title's cool. We have the title policy and survey. Pretty much all of that are just the details: who buys the title insurance and the responsibilities for getting a property survey. It protects against legal issues with property boundaries and ownerships. Pretty self-explanatory. So we're going to move on to 2 in title notices now. We have membership in a property owners association. The property is or is not subject to a HOA, basically. In this example, they are in an HOA, and you have to be a part of an HOA if you fall in that HOA. Makes sense. Statutory tax district. If you're in a statutory tax district, that has to be disclosed. Tidewaters. We don't deal with tidewaters in BASTROP. Annexation. If you are located outside of a municipality, that has to be disclosed. Property located in a certificated service area of a utility service provider, that will have to be disclosed. Public improvement districts, that will also have to be disclosed. Transfer fees, that's if there's transfer fees related to that HOA or any other things that needs to be transferred. Propane gas system service area, that'll have to be disclosed as well with an addendum. Notice of water level fluctuations, so if you're on a reservoir or lake, that has to be disclosed, because, you know, if there's a crazy flood or something and you don't know that it's there, you can sue. But with this, you actually know it's there, so you can't sue. Good deal. Required notices. The following notices have been given or are attached to this contract. For example, MUD, WCID, or PID notices. Alright, so we have number 7, property conditions. This is going to cover inspections, seller disclosures, and any known issues. It's crucial for buyers to understand what as-is condition means. So, A, access, inspections, and utilities. Basically, the seller is going to have to let the buyer and the buyer's agent have reasonable access to the property. B, the seller's disclosure. This is very important. Disclosure is going to have everything on it that the seller knows is wrong or not wrong with this property. So in this example, the buyer has already received the notice, but if the buyer has not received the notice, they would check the second box, and they're going to give the seller X amount of days to give it to them. Or the seller is not going to give it to them, and that will be here. Not very common. Seller's disclosure of lead-based paint. So if the house was constructed prior to 1978, that has to be checked out. Acceptance of property condition. So as is means the present condition of this property and any and all defects without warranty, except for the warranties of title and the warranties in this contract. It's going to be finished on the second page right here. So at the top here, it's the buyer accepts the property as is, or buyer accepts the property as is, provided seller at seller's expense shall complete the following specific repairs and treatments. You have to be very specific here on what exactly you want done. So in this condition, they don't care. They're just going to accept it as is. Lender required repairs and treatments, if there's going to be lender required repairs related to FHA, things like that. Completion of the repairs needs to be documented and done by a licensed professional. Environmental matters, if there's going to be maybe endangered species or something, that has to be added or included with an addendum promulgated by TREC. Residential service contracts, which is what we were talking about earlier. So, well, not, we haven't talked about this yet. This is home warranties. Buyer may purchase a residential service contract from a provider or administrator licensed by the Texas Department of Licensing and Regulation. If the buyer purchases a residential service contract, the seller shall reimburse the buyer at closing for the cost of this residential service contract in an amount not exceeding to, in this example, $375. The buyer should review any residential service contract for the scope of coverage, exclusions, and limitations. Purchase of a residential service contract is optional. Similar coverage may be purchased from various different companies authorized to do business here in Texas. Cool. Brokers and sales agent disclosure. 8. So this is if a broker or sales agent has either 10% trust in a property, or if they're a family member, or it's one of the business entities that are associated or a party of this property. Broker fees. All obligations of the parties for payment of broker fees are contained in their separate written agreements, which are the listing agreement and the buyer rep agreement. 9A, we've got closing. Closing of the sale will be on, in this example, November 28th, 2022, or within 7 days after objections have been made in 6D, or within 7 days after those objections in 6D have been cured or waived, whichever date is later. Cool? Great. At the bottom here, it's just designating exactly what's going on at closing. So at closing, the seller will execute and deliver a general warranty deed conveying title to the property, containing the title of the property to the buyer, and showing no additional exceptions to those permitted in paragraph 6, and furnish tax statements or certificates showing no delinquent taxes on the property. Number 2 is going to be buyer shall pay the sales price in good funds acceptable to the escrow agent. Number 3, seller and buyer shall execute and deliver any notices, statements, certificates, affidavits, releases, loan documents, transfer of any warranties, and other documents reasonably required for the closing of this sale and issuance of this title policy. There will be no liens, assessment, or security interest against the property which will not be satisfied out of the sales proceeds unless securing the payment of any loans assumed by a buyer, and assumed loans will not be in default. Private transfer fees, as defined in Chapter 5, Subchapter G of the the Texas Property Code. I cannot talk today. Happens. Gotta do what you gotta do. They will be the obligation of the seller unless provided otherwise in this contract. Transfer fees will be assessed by a property's owners association, so the HOA, and are governed by the addendum for property subject to mandatory membership in a property owners association, which will be added to this contract. Number 10, we have possession, buyer's possession. The seller shall deliver to buyer possession of the property in its present or required condition, ordinary wear and tear accepted, upon closing and funding, or according to a temporary residential lease form promulgated by TREC. So, if they're only moving in after they sign the papers, then you'll check this box. But in this case, they're either moving in later or moving in before, whichever temporary lease is added. Smart devices, just make sure you gotta send over all your smart devices to the new owner. Special provisions, this is for only statement of facts about the property. We're not deleting, modifying any provision in this contract. Unless an attorney did it, then they can do whatever they want because of an attorney. Cool. Settlement and other expenses. So, details who pays for what at closing, and misunderstandings here will cause delays, so clarity is very, very important. Following expenses must be paid at or prior to closing. Expenses payable by the seller. These are all the seller expenses. Release of existing loans, including prepayment penalties and recording fees, release of seller's loan liability, tax statements or certificates, operation of deed, 1/2 of escrow's fee, and the other expenses payable by seller under this contract. Seller shall also pay an amount not to exceed blank to be applied in the following order. Buyer's expenses, which the buyer is prohibited from paying according to FHA, VA, or Texas Veterans Land Board, or other governmental loan programs, and then the other buyer's expenses that are allowed to be paid for by the lender. So if they're using an FHA or VA, the seller is going to have to pay at least a little bit, because there are closing costs that buyer is not allowed to pay. Expensables payable by the buyer, which these are going to be the buyer's expenses. These are going to be appraisal fees, loan application fees, origination charges, credit reports, preparation of loan documents, interest on the notes from date of disbursement to 1 month prior to dates of first monthly payments, recording fees, copies of easements and restrictions, loan title policy with endorsements, recording fees, copy of easements and restrictions, loan title policy with endorsements required by the lender, loan-related inspection fees, photos, amortization schedule, 1/2 of the escrow fee, all prepaid items including required premiums for flood, hazard, insurance, reserve deposits for insurance, ad valorem taxes, and special governmental assessments, final compliance inspection, courier fee, repair inspection, underwriting fee, water transfer fee, expenses incident to any loan, PMI. So if you're doing an FHA loan, if you're taking out a loan and you're putting less than 20% down, you'll probably have PMI, private mortgage insurance, VA loan funding fee, or FHA mortgage insurance premium. So if you're having an FHA, they have their own MIP, they have their own PMI, which is MIP, mortgage insurance premium, as required by the lender, and other expenses payable by the buyer under this contract. If any expense exceeds the amount expressly stated in this contract for such an expense to be paid by a party, the party may terminate this contract unless the party agrees to pay such excess. The buyer may not pay charges and fees expressly prohibited by the FHA, VA, Texas Veterans Land Board, or other governmental loan programs. Alright, so number 13, we got prorations. So basically, taxes, things like that are going to be prorated for the rest of the year. Casualty loss: if any part of this property is damaged or destroyed by a fire or other casualty, the seller shall restore the property to its previous condition as soon as reasonably possible. But if in any event by the closing date the seller cannot do so, the buyer may terminate the contract and the earnest money will be refunded to the buyer, and extend the time for performance. Refunded to the buyer, or they can extend the time for performance up to 15 days, and the closing date will be extended as necessary, or accept the property in its damaged condition with an assignment of insurance proceeds, if permitted by seller's insurance carrier, of course, and receive the credit from the seller at closing in the amount of the deductible under the insurance policy. Seller's obligations of this paragraph are independent of any other obligations the seller will have. Default: this is going to define the consequences if either party fails to meet their contractual obligations. So, if the buyer fails to comply with this contract, the buyer will be in default, and the seller may either enforce specific performance, such as seek relief, as may be provided by law, or, and both, B, terminate the contract and receive the earnest money as liquidated damages. If the seller fails to comply, now the seller's in default, the buyer can either enforce specific performance, and both, B, terminate this contract and receive earnest money back, thereby releasing both parties from this contract. 16 is mediation. So basically, we don't want to go to court, and if we can keep it out of court and solve it that way, cool. 17 is attorney's fees. Basically, whoever loses the battle in court, if it goes to court, is going to pay for the other person's attorney's fees at the end. Escrow. Escrow agent is not a party to this contract and does not have liability for performance or non-performance of any party. Basically, just defining what the escrow agent is and does and doesn't do. Escrow agent's not a party to this contract. They're just there to make everything go smoothly and make sure the money goes where it's supposed to go. Representation: all covenants, representations, and warranties in the contract survive until closing. If the seller's not who they say they are, or the buyer's not who they say they are, contract's void. Federal tax requirements: if the seller's a foreign person as defined by IRC and its regulations, or if the seller fails to deliver an affidavit or certificate of non-foreign status to the buyer that the seller is not a foreign person, then the buyer can withhold from the sales proceeds an amount sufficient to comply with applicable tax laws and deliver the same to the IRS together with appropriate tax forms. 20 is federal tax requirements. So if the seller is a foreign person, they have to disclose that. If the seller doesn't disclose that, the buyer can be like, hey, and then withhold some funds from the sale to basically pay for the taxes that are about to come in. Next page, we've got the fun page. So we've got notices. Basically, we have making sure that everything has been delivered to the buyer and delivered to the seller at the right addresses. Agreement of parties. So these are going to be all the extra addenda that's going to be added. So this one is seller financing addendum. This one's going to be the addendum for that HOA. Seller's temporary residential lease. So that means the seller is going to be staying in the property after the property is sold for a certain amount of time. Consultant attorney before signing. They didn't do attorneys, but your attorney on the buyer side and your attorney on the seller side would go here and there. This page, so we have executed on this date. So the broker will fill in the date of the final acceptance, and that will be the final acceptance and the effective date. Buyer, seller, buyer, seller. So in this case, Robert Strassman selling it to this married couple. So we've got Devon and Christine. And last part, well, one of the last parts, broker information. So buyer's broker, seller's broker right here. If there was an intermediary, you would check this box, and this information would all be under here. Disclosure, pursuant to a previous separate agreement such as MLS offer of compensation or other agreement between brokers, listing broker has agreed to pay the other broker a fee of, in this case, 3%. This disclosure is for informational purposes and not change the previous agreement between brokers to pay or share a commission. And we have the receipts. So option fee receipt, earnest money receipt, contract receipt, and additional earnest money receipt. In this case, I didn't have any. That is everything. I think we're good to go. Cool. So that is a wrap on our line-to-line breakdown of the Texas 1-4 Family Residential Resale Contract. Remember, every single line and clause is very important to understand your rights and obligations fully. If you found this guide helpful, please like, subscribe, and share it with anyone facing a real estate transaction in Texas. Drop your questions or topics that you would like covered in future videos in the comments below. And thank you so much for watching. Have a great day. Bye.